All right, welcome, Professor Gerda Puhol. Welcome. This is our last class. It is a makeup class because of a couple of our Thursday sections were canceled because of the storms that we had this semester. Ian, I believe, and Nicole, a couple of them fell on a football. So just so that we have all our classes covered, I am recording tonight's class as well for your fellow classmates. Tonight, it'll be a fairly short class. I just want to cover three topics. I put them in the chat. We'll cover the main forms of corporate governance, main forms of doing business. We'll talk about business ethics, two competing major theories of business ethics. And then I want to conclude with something called the Accountable Capitalism Act, which is a proposed piece of legislation which is now pending in the Congress. And it would, if that were to become enacted into law, it would basically change everything that I'm teaching you in this class today. And so I do want to anticipate the possibility that there could be this change. And I want to introduce you to this proposed piece of legislation. So what I've done for today is I have opened up the last module that corresponds with this class. Everything I talk about, you'll find it in there. But I haven't posted any new assignments since the final project, and a couple of our old modules from when the storm hit are still open. All those things are due tomorrow. So what I will do is I prepared a kind of TED Talk presentation. I'll pull that up now, and then we'll just jump in and without further ado, space screen share. All right, great. And one last thing for those of you watching live, I know we have a small group, our hardcore group. If I do get disconnected, just stay on. I have a backup device. Sometimes the internet can go on and off, when we do the Zoom, it's a high bandwidth, etc. All right, so go ahead and expand this. And these are our three topics, and let's jump in. I first want to talk about corporate governance and Facebook. Now it's called Meta Platforms, Inc. And the movie, The Social Network, about the founding of Facebook, really has a nice chronology of Facebook's evolution as a company. It gives us a way of illustrating with a real example, how a business can be organized and what the main forms of corporate governance are. You'll notice I have on, Facebook began, you could say, when Zuckerberg, as a sole proprietor, when Zuckerberg is doing all these projects at his school at Harvard, he's doing something called Course Match, where if you sign up, you could find out what classes other people who have signed up for Course Match are taking. He's, as part of his apology for the face mash, he did a website for the Association of Black Harvard Women, ABHW. So he's doing all these little projects on his own. And though, he's going to invite Eduardo Saverin to be his partner. And what's really cool about that is, think of all the big companies like Microsoft. You use Word, PowerPoint, Excel, about Microsoft, right? That began as a partnership between Bill Gates and Paul Allen. Apple, right? If you have an iPhone, Apple Watch, iPad, whatever, use Apple products at all. Apple began as a partnership between Steve Jobs and Steve Wozniak, also in the 1970s. More recently, Google, if you use Google search like I do, that began as a partnership between Sergey Brin and Larry Page for students at Stanford. And so a lot of companies began as partnerships. And notice, right, later than Facebook evolved. One of the things that Eduardo does as the CFO of the company is he registers the Facebook as a limited liability company in the state of Florida. And I've included in the module I've included the articles of organization of the Facebook LLC. And then, in the movie, there's this great scene where Zuckerberg, Jesse Eisenberg, right, and Justin Timberlake, who plays Sean Parker, they're up in an elevator. They're going to meet Peter Thiel. And Peter Thiel says, okay, we're going to set you up as a Delaware corporation. And so Facebook, for a while, was a privately held corporation. And then eventually Facebook went public, right? It listed its shares on the NASDAQ, the big New York City. And now it's a publicly traded company. And then last year they rebranded. Now they're called Meta Inc. Meta Platforms Inc. as part of the shift to the metaverse. And so you'll notice here I have maps of some states because under existing law, and this is what I want you to know, is a company is a creature of state law, depending on where that company is registered, or if it's a partnership where the partners live and do business. Sole proprietor, where the sole proprietor lives and does business. So initially, right, Facebook, you could say, was a Massachusetts company, right? Because it was a sole proprietorship operating there in Cambridge, Harvard Square, then it became a general partnership. Once Eduardo registers Facebook as a limited liability company in Florida, it became a Florida company. And then when Peter Thiel comes in and makes the major investment, Facebook becomes a Delaware corporation, buys out the LLC, right? Shares to Peter Thiel, Sean Parker, Eduardo Saverin, Mark Zuckerberg, Chris Hughes, all the people who went on to found Facebook. And so that's one thing I do like about the movie, that it gives you that, evolution. So each of these forms of corporate governance, what I want to focus on, because from my previous semester, when I've done surveys, I realized most of my students are super savvy about this. They already know all this stuff. What I do want to focus on are just a couple of things. The main disadvantage of a sole proprietorship or a general partnership is unlimited legal liability of the owner. If it's a partner, if it's a proprietorship, or of the partners, if it's a partnership. With an LLC entity or a corporation, right, there's limited legal liability in that not the owners, not the shareholders of a company or the owners of the LLC, they have limited liability. Their personal assets cannot be touched. Now, one key thing, this is where a lot of people often make a mistake when they're starting a business. They may register as an LLC, and you have, for example, one advantage of an LLC is you can have a single member LLC where only one owner. You have all the benefits of a limited liability company and all the flexibility of being a sole proprietor, but limited liability. But the key is you have to have separate bank accounts for the owner or owners and for the LLC. For the corporation, especially privately held corporations, the shareholders have to have separate bank accounts from the corporate bank account. That's really, really important. In the movie, when Eduardo gives Zuckerberg, that $20,000, so that he can hire the first 2 interns and go out to California and rent the place over there. Most likely, if Eduardo was smart, the movie doesn't really say this, but if Eduardo was smart enough to create a limited liability company, and he did that in Florida, then probably smart enough to create a separate bank account for the Facebook LLC, so they can get the benefit of limited legal liability. So it's really, really important. Otherwise, courts do have the ability to, what the common law calls, pierce the corporate veil, to impose personal liability on holders of a corporation or on the owners of an LLC if, for example, there aren't separate bank accounts. If, for example, the company was created in order to defraud creditors. Those are some of the common exceptions where the corporate veil can be pierced. But what I want to focus on here is, you'll notice Facebook became a Delaware corporation. And what many of my students may not know is that it turns out most Fortune 500 companies, and in fact, most companies that are listed on the New York Stock Exchange or the NASDAQ, the big board in New York City, they're Delaware corporations. In fact, I have a little map here showing you all of some of the largest, most well-known companies, including like the Hershey's chocolate company, right? There's a whole city in Pennsylvania named after Hershey, right? Where the headquarters are, but they're a Delaware corporation. Ford and General Motors, right? You think of Detroit, you think of Michigan, but legally they're Delaware corporations. Facebook, right? As we said, all of these companies, Google, right? Yeah, they're located in Mountain View, California, but legally they're registered in Delaware. So what I want to explain to you is why a lot of companies choose to register in Delaware. And there's really, what it boils down to is Delaware has something that's super special. They have a court called the Chancery. And that Chancery court, the judges are called chancellors. And legally speaking, it's what lawyers call a court of equity. What that means is, it goes back to English history. I won't go into all the details. The bottom line is, in a court of equity, there's no jury. The judge, or in this case, the chancellor, makes all of the decisions. And so the Chancery Court in Delaware, these judges, these chancellors, they're super specialized in Delaware corporate law, and they're super fast and efficient. And let me give you an example. Elon Musk and Twitter, he basically, made a deal with Twitter back in May of this year. Then in July, he was going to buy Twitter. Then in July, he backed of the deal. And guess what? He sued, right? The Twitter, the board of directors, they sue Elon Musk to, force him to live up to the agreement or pay $1 billion in liquidated damages, which is what the penalty clause was in that buyout agreement. And the Delaware court scheduled the trial for Monday, October 17, just a few weeks after all of this, less than, 2.5 months. And then, to avoid going to trial, Elon Musk, asked the court, his lawyers, can you give us an extension of time? I think I will buy Twitter after all. I'll close the deal. And the court gave Elon Musk, the Delaware Chancery Court, gave Elon Musk until Friday of that same week. Friday, I believe it would have been October 21st, to close the deal. And in fact, he closed it on that Thursday, right? That gives you some example. Compare that to the previous module where I showed you the docket of the Connect You lawsuit against Facebook when the Winklevoss twins, the Winklevi, sued Zuckerberg, for stealing their idea. That case took, 4 or 5 years, and it never even went to trial. It got settled out of court. It was still going on when it got settled out of court. It would have taken maybe another year, at least, before it goes to a jury. So it gives you some idea of one of the advantages of registering in Delaware, that you now have the advantage of these special Delaware chancery courts, super knowledgeable about general corporation law of Delaware, and very fast and efficient and professional. The other advantage, though, is that the Chancery Court in Delaware has adopted a body of law that's very pro-business. This is called the business judgment rule. And what I have here is a slide explaining what the business judgment rule is. I want to give you an example. Think about Facebook. I don't know if I have anybody in the class who's a shareholder of Facebook, but if you were a shareholder of Facebook at the beginning of this year, each one of your shares were worth almost $400. That's a pretty valuable company, right? But what's happened, though, Zuckerberg, and many of you may know this, right? He's made a bunch of bad business recently, beginning with he's invested all this money in something called the metaverse, right? And the metaverse really, you've seen, maybe you know what I'm talking about. Zuckerberg's version of the metaverse, to put it politely, is pretty lame. Nobody is really using it. Hasn't been commercialized. Facebook has a lot of money on this. There's no no prospect that is really going to pan out. A Facebook stock today, it's like 150 or, it's below half of what it was at the beginning of the year. And so often, you may, as a shareholder, you'd like to sue Mark Zuckerberg, and the board of directors for making these bad business decisions. But the Delaware Chancery Court have developed this body of case law and this specific doctrine called the business judgment rule. And what it is in plain, the actual formula here, the legal formula, but what it is in plain English, it gives the CEO, the board of directors, the benefit of the doubt. You try to sue Mark Zuckerberg for making a bad business decision, as long as Zuckerberg can show that he made the decision to invest in the metaverse in good faith, think about it, right? All these kids are doing Roblox and Minecraft, very popular sites. Maybe the metaverse will eventually be, very popular. So that seems like a decision. Use of care that another business person would make, seeing this potential business opportunity, would another business person in the same position as Zuckerberg have made the same decision? And finally, is the decision reasonable? And what the Delaware courts say there is that, did Zuckerberg or whoever's making the decision, did they consult all relevant information at the time they made the decision? In other words, if you make a bad business decision that turns out to be terrible, in hindsight, doesn't mean you've done anything wrong, so that if you do make a bad business decision, again, as long as it's reasonable, you've consulted all the relevant information, as long as it's the type of a decision that any other average business person would have made given that information, and you've made it in good faith, thinking that it would work, you can't be sued. Courts have to dismiss it. And if you're a Delaware company, even if you're sued in some other state, even if you're not sued in Delaware, the courts of other states are obliged to apply Delaware law, including Delaware precedents, to that litigation. So the business judgment rule, in a nutshell, is why is why Peter Thiel recommends to Zuckerberg, hey, as a condition of my investing $500,000 in your company that you just started, at the very least, I need you to reorganize in Delaware, register your company in Delaware, so that if you ever do get sued by one of your shareholders, like Eduardo, eventually he'll have to counterclaim. We saw that whole thing in the last class. The courts will have to apply the business judgment rule. Your decision to dilute Eduardo, for example, was that made in good faith? That's actually a close one, right? It's probably why the case settled. Is it the type of decision another business person would have made? Maybe, right? Did you consult all the relevant information at the time you made the decision? Most likely. So, but notice that business judgment rule, it really benefits the corporation. It really benefits, the CEO, the board of directors, because now, they can defend themselves whenever they're sued by their shareholders. All right. So I did want to let you know that companies that do decide to register, pardon me, either as a limited liability company or as a corporation, whether it's privately held, privately owned, or publicly traded, that's one of the reasons, probably the main reason why Delaware is still the favorite jurisdiction. But the main thing I want you to know is that a corporation is a creature of state law. You can pick any of the 50 states or, any of the overseas American jurisdictions, like U.S. jurisdictions, like American Samoa, Commonwealth of Puerto Rico, USVI, Micronesia, all the Guam, to register your company. Then you're legally can do business then in any state. But you do have to pick one of the states to register your company. But Delaware continues to be the most popular state because of those specialized chancery courts, and because the chancery courts have developed this body of case law that includes the business judgment rule. Now, I want to say one more thing about corporate governance, and I want to give Zuckerberg, I've been highly critical of him throughout the semester, but I want to give Zuckerberg a shout out and give him some credit. He is trying a new method of corporate governance that's never been tried before. What he did is he went ahead and created an independent board. It's technically a trust company that Facebook has fully funded with $350 million to operate for the next 5 years. And then they did appoint a director. And then that director has appointed 40 people, including the former prime minister of Denmark, including former Nobel laureates, including, for example, in the Trump case, all that after the January 6th insurrection, Trump was kicked off of the Facebook platform. Well, Zuckerberg referred that decision to his oversight board. These are the members on that particular board. There's 40 members on the oversight board, but when they hear a case, they meet in smaller groups of 3 to 5. And you can see here who they are. Very prestigious law professors with expertise in the First Amendment. Jamal Green's a friend of mine at Columbia. He's an awesome, really original scholar. But all of these people are really top people, you know what I mean? And so what Zuckerberg said is that he would abide by the decisions of the oversight board, whatever the decision is. And here the oversight board, just a quick summary, they did decide that Facebook had the authority, they were able to deplatform or, censor Donald Trump, kick him off. But because of due process, because of fairness, what we saw in our last class, they had to put a time limit on that. They had to say, look, it can't be indefinite. All right, apologize for that. I was muted. Okay, we're back on. We have a healthy group considering it's the last class. Great. I was saying about the Facebook Oversight Board. Some people say it doesn't go far enough because decisions not to kick someone off the platform. Let's say you don't agree that somebody made a racist post and they're not kicked off. You can't challenge that. So that's limited jurisdiction. I like to look at the glass as being half full. And in other words, that, it's true. You could say the oversight board doesn't go far enough. They also have no jurisdiction over Facebook's overall content moderation policies, only over specific decisions applying that content moderation policy. But I will give Zuckerberg credit that, no other company has done this, create an independent oversight board and then agree ahead of time that we're going to abide by the decisions of that oversight board in that jurisdiction that it has, however limited. So I see this maybe as a step in the right direction. It's certainly experimental. This is a new form of corporate governance that really has never been tried before. And I just want to bring that to your attention that Zuckerberg does get some credit. Now, in fairness, Zuckerberg didn't really talk about this idea until after the New York Times published the expose showing how these Russian, agents were using Facebook to spew propaganda, after the Cambridge Analytica scandal, so Zuckerberg in a way was dealing with this big, bad public relation problem, about 4 or 5 years ago. And then he says, but to his credit, he said, okay, let's try something new to see if we can do better. So I just want to be fair to Zuckerberg, again, it may not go far enough, but I'm looking at it as, hey, at least he's trying something new. Maybe if it works, we can expand it further. All right, let me go ahead and continue where we were here. Let me make sure. Oh, good. We are still recording. So let me just delete that over there. All right, let me go back to our presentation. Next part of the class, I want to talk about the two major theories of business ethics. Or often business ethics, the fancy term is corporate social responsibility. One theory is basically make as much money as you can. Maximize your profits. This is also called the moral minimum because, the thing is, you still have to comply with the law, but as long as you're complying with the law, your company has met its ethical obligation to society. The other model of business ethics is more robust. That's often referred to as good corporate citizenship. It's the stakeholder model, which I'm going to discuss in just a few moments. Before I discuss, I want you to think someone like Mark Zuckerberg, someone like Tim Cook at Apple, someone like Eric Schmidt at Google, whatever company you're doing your final project on. What model of business ethics is that company following? So let me describe these two models and also discuss the good and bad, strength and weaknesses of each of these models. And then I'll let each student decide for themselves, what you think is the best model. Let me talk about this maximizing profit model first. It's called the Friedman Doctrine. If you want to know more about it, I included the Wikipedia page. It's called the Friedman Doctrine in honor of Milton Friedman. He was an economist at the University of Chicago, Nobel laureate. At the time he was alive, he was a rock star. He had his own series on PBS called Free to Choose with his wife, Rose Friedman. I remember watching that as a kid, and it really influenced how I think about the world. And what Milton Friedman, he was on the cover of Time magazine. This guy was a rock star, and he also wrote this book that has since gone on to sell 40 million copies and been translated into 17 different languages called Capitalism and Freedom. And in that book, later he'll expand this in an essay he wrote for the New York Times magazine. He says, look, the corporate social responsibility of business is to maximize its profits. That's the Friedman Doctrine. Now, in Capitalism and Freedom, and in his essay, he says, of course, the company has to comply with the law. Like, you can't be committing fraud and defrauding, your creditors and your customers and stuff like that. But as long as you obey the law, as long as you don't do anything illegal, your ethical obligation is met, so your job is to make as much money as possible. Now, in defense of the theory, this sounds like the greed is good speech in Wall Street. I will say that Milton Friedman's theory has a very, very influential intellectual pedigree because it goes back to Adam Smith, the founder of economics, political economy. He basically, Adam Smith, you may recall the invisible hand. economics class. And the invisible hand is, as long as everybody is pursuing their own self-interest, that's going to maximize the interest of society overall. Again, everybody has to act within the law, but this has a very powerful intellectual pedigree. Now what I want to do, because I'm a professor, I want to be fair and balanced. I want to give you the other side of the story. And it turns out I can refute, or at least challenge, the Friedman doctrine, of which I'm very sympathetic. I'm a big Adam Smith scholar myself, and I can do it in a single picture. This is Martin Shkreli. He's often referred to as Pharma Bro. It's true he's in jail right now for tax fraud, but I don't want to talk about the tax fraud case. That's an illegal activity. We all agree that's wrong. But before he got busted for tax fraud, he bought the rights to a patent for a pharmaceutical drug, and then he jacked up the price of that drug by 5,000%, And he became, at the time, and to this day, I think he still is, the most popular or, notorious man in America, businessman in America, for doing that. But think about it. What he did was perfectly legal, right? He bought the patent fair and square. And then as a owner of the patent, he has a monopoly for 20 years, right? He sets the price, right? That's the monopolist price. And in other words, right, he did everything that Milton Friedman said you should be doing, right? But nonetheless, that rubs people, and I think rightfully so, the wrong way. You want an example more close to home? Florida, after a storm, and a gas station that jacks up its price. Gas is already expensive as it is, although the price is starting to come down. Imagine you're a gas station owner, then you take advantage of everybody who needs gas, and you jack up the price to 20 a gallon, something like that. You know what I mean? Most people, and economists would say that's the efficient, allocation, that's how you decide, willingness to pay. But most people will say that's wrong. You're taking advantage of people's, vulnerability after a storm or a natural disaster. So the Friedman doctrine has that weakness, that, if you follow it, doesn't mean that you're not going to be, unpopular, So let me show you why we have this other theory, the stakeholder model of business ethics. And the stakeholder model, actually, it's very powerful and very intuitive. What it is, and I have here, for example, 5 groups or stakeholders. A stakeholder is just a group of people who are impacted or, who are affected in one way or another by any decision the company makes. So these are the main stakeholders, right? The employees, for example, does the company, is it going to relocate? What wages are going to be paid? What bonuses are going to be given? But also, the people, the other companies that your company does business with, your suppliers, for example, and your creditors, your debt holders. Also, the local community in which the company does business, or where the employees live, that kind of thing. And of course, the customers, it goes without saying. Right. So what the stakeholder theory or model of business ethics does, it says, look, at the very least, if you want a company to be a good corporate citizen, the company, when making a decision, has to, at the very least, take into account the interest of all of its stakeholder groups. Let me give you an example of this to show you just how powerful it is and how it transcends even politics. The example, it does go back to 2016, but I still think it's the most dramatic example of the stakeholder model. It's when Donald Trump called out the Ford Motor Company and the Carrier Corporation for closing their factories in the United States. Carrier, for example, had some factories in Indiana. They're going to close it down and relocate some of them to the People's Republic of China, some of them to Republic of Mexico, overseas, right, to get the lower labor cost and lesser environmental regulations. So Trump called that out. Hey, that's not good for your employees. These employees, of course, are also voters, right? And so a lot of political scientists, beyond my expertise, but a lot of political scientists said this is one of the reasons why Trump may have won the 2016 election, at least, because he was advocating for, if you will, employees. That's a stakeholder model. Hey, take into account your employees before you make a decision. All right. So we see this is kind of powerful. But now, again, I'm a professor. I need to be fair and balanced. I need to show you there's a weakness with this theory. Now, unlike the Friedman doctrine, where I can just show you a picture of a despicable individual, Martin Shkreli, and that pretty much refutes the entire Friedman doctrine. Here, it's harder to do. This is a very powerful theory, but there is a weakness. I think there's a problem with the theory, and I put it into words here. It's wishy-washy, because I'm going to tell you something that every time. And most of my, I notice most people in business schools, When I go to conferences, they're all about the stakeholder model. And I always ask them, well, what weights do you assign to each of the groups? The reason why that's fundamental is because in the real world, the interests of the stakeholders of your company may very often collide or be in conflict with each other. And then how do you decide then, what do you do? Again, let me give you the carrier example just to show you what I mean by my critique here. Yeah, it's bad for the workers, the employees, right? If the carrier shuts down in the USA and moves those factories overseas, right? But then again, I'm assuming that carrier, if you get lower labor costs and transportation costs, with free trade with Mexico are not going to be that much, I'm assuming the price of carrier products, air conditioning and heating devices are going to be a lot lower. So that will benefit consumers, who aren't working for the company. So when you have a conflict here between your employees and your customers, how do you decide, which group then to privilege, right? Unless you have a theory telling us, okay, I'm going to assign, let's say you assign equal weights to each of these groups, just to make it simple, but again, when these interests collide, what do you do when there's a tie? Or what do you do when there's conflicting? And so that's what I mean by wishy-washy indeterminate, because then, company's going to do whatever it does anyways. I'm going to say one thing, for me, probably the stakeholder model is still more, if you will, intuitively appealing, because at least you do have to, at the very least, it's not very demanding. However you weight these interest groups, you take into account how your company's decision will affect them. But I suspect one advantage of the Friedman doctrine is that from a descriptive point of view, if all you care about is to describe how companies actually act, not what they say they're doing, but what they're actually doing, probably the Friedman doctrine is a better description of reality. Now I'll say, I'll give you an example. It's called greenwashing. You may have gone, if you've gone to a hotel, you'll see the little sign says, we the hotel care about the environment, so we're not going to wash your towels, unless you specifically ask for it, And so does the hotel really care about the environment? Is that why they're not washing your towel? Or is it just about saving the labor costs? Normally these towels, when I was in Puerto Rico at a law firm, I represented the Caribe Hilton, one of our firm's clients. And I'll tell you, the towel company, it was actually a separate company. Hilton doesn't wash their own towels, or they actually have a contractor that provides the towels and washes them and replaces them. So you can see that, if I have to wash less towels or send less towels to my contractor, then my contractor may charge me less, if it's if they're charging me by weight of towels or amount of towels, that kind of thing. So I just throw that out there that, maybe as a matter of descriptive reality, the Friedman doctrine really describes what's going on. Now, that said, though, that's not the end of the story, because I could come back to you and say companies like Whole Foods, very successful grocery chain, sometimes, or Starbucks, they have this ethical sourcing campaign, where they only buy coffee beans from growers overseas who are committed to paying their workers, a living wage. The idea here is that sometimes the best way to make the most money, to maximize your profits, is by doing the right thing. Because today, the reality is a lot of consumers are very savvy and they do care about ethics. They do care about how the company treats their workers and their contractors and their other stakeholders, And so sometimes, maybe the best way, ironically, maybe the best way to make the most money is by doing the right thing, and paying good wages, and taking into account various stakeholder interests and trying to balance them as best you can. So I just wanted to give you that big picture of the two main theories of business ethics. And then you decide for yourself which one is descriptively most accurate, and normatively, which one should businesses actually try to follow, regardless of what you think is the most descriptively accurate, So just want to throw that out there. All right, there's one last thing I do want to talk about, because it's going to change all of this that I've just taught you about business ethics and corporate governance. It's something called the Accountable Capitalism Act that was introduced in 2020 into Congress, into the Senate, by Senator Elizabeth Warren, who, by the way, is a friend and colleague of mine. She was a professor at Oklahoma University in Norman, Oklahoma, and then at Harvard University, where she taught bankruptcy and contracts. I know her from conferences. And then AOC, the famous Alexandria Ocasio-Cortez, in the House of Representatives, has introduced a companion bill, a copycat bill, in the House as well. So now I will tell you, Probably in the foreseeable future, this bill has no chance into getting enacted now that the Congress, now that the Republicans control the House, but of course by a narrow minority, 2 or 3 votes. We'll see what happens in the Senate. I think the Democrats still control the Senate, but I think, those of you doing the final project, right? One of the things I asked you is, what is the salary of the CEO? And what I didn't ask you is, what is the average salary of the workers? One of the things that and most of us are going to be workers, not CEOs. You know what I mean? We're going to work for a company. Maybe some of us will start our own company. Maybe some of us will rise to become the CEO of the company. But for most of us who are workers, right? You may have learned this from your other classes. Worker salaries have basically stagnated, even though productivity has gone up. Whereas CEO salary, CEO pay has skyrocketed, And I'm not against people making money, but how come the workers aren't making money? Just the top people are making money. So what this bill does, that's what motivated Senator Warren. And I want to tell you what it does, and you can decide for yourself whether it's a good idea or a terrible idea. The bill basically does a lot of things, and maybe not all of these things will get enacted if it ever, if it does go further in the committee process and gets a floor vote eventually, but I think what the bill does is so important that people are going to talk about this stuff in the future. And it does 3 things. Number one, it's going to federalize corporation law. Well, let me back up, say one thing. The bill has a threshold. Right now, the threshold is your company has to make $1 billion, that is to say $1,000 million per year for this law to apply to you. I looked it up. There's about 3,000 or so companies that, would have to comply with the law. What would these companies have to do? These would be the biggest companies: Google, Meta platforms, Facebook, Amazon, Apple, etc., right? Microsoft. What would they have to do? First of all, they would have to register, not just in one of the states, they would have to register in, their company charter with a new office called the Office of Corporations. The Office of Corporations, the way the bill is written, would be under the aegis of the Department of Commerce. Why? Because it's the Office of Corporation that will have the power to enforce the provisions of the bill. And there's 2 provisions that strike out, that really strike me, get my attention. One is it would replace the business judgment rule, with the stakeholder model. It would basically legislate the stakeholder model. It would say that if you're a company that has $1 billion or more per annum, in revenues, you have to, as a matter of law, take into account all of the interest of all of your stakeholders. And you'd have to document that, whenever you make a decision, And then number 2, one of the things that I personally find interesting about the bill, is it actually begins to assign some of the weights. Remember my criticism of the stakeholder model? How do we weight these different stakeholder groups? It would say that, think about it, right? If you're a company and you're saying that, you're about stakeholder model, how come there are no workers on your board of directors? Go into the module, look at Facebook's board of directors. You're not going to find a single rank and file employee on that board of directors. And I don't mean to pick on Facebook. You can pick the board of directors of any Fortune 500 company, of any publicly traded company on the big board, NASDAQ or New York Stock Exchange, and you're going to see the same thing. Board of directors, basically CEOs of other companies serving on the boards of other companies, powerful, rich and powerful people. Now I'll say to Facebook's credit, you look at their board, they have a good gender representation there. They have good, ethnic and race diversity, which you can't say for a lot of companies. But what they don't have is a single worker. So what Senator Warren and AOC's bill would do, it would say each of these big companies would have to have at least 40% of the board of directors would have to be elected directly by the workers. Under existing corporation law, it is the shareholders that elect the board of directors. And the thing is, what happens in real life, right? The CEO appoints a slate of directors that he or she wants. And then the shareholders generally ratify, what the CEO has proposed, kind of rubber stamp. You don't really see that much direct democracy in shareholder meetings. And so that is starting to change. There are some shareholder activists, but, they only own a small percentage of the company, right? So it's shareholders as a whole, like Facebook shareholder group. Zuckerberg not only owns a lot of shares, voting shares, but Dustin Moskovitz, a co-founder of the company, has given Zuckerberg a proxy. So Zuckerberg basically controls, the shareholder votes, on these type of things. So, I kind of find this bill to be very interesting, and that it calls them out. You say you're about the stakeholder model. Okay, we'll put some workers on your board. I want you to think about the UCF Board of Trustees, or if you have friends at UF or FSU, those board of trustees, right, always have the SGA president, the student body president, as a either voting or non-voting member on the board, right? Because you have to at least hear what the students have to say by at least allocating one of the seats to the board to them, So that's what this bill would do. Now, I just want to say again, and this is a normative thing, right? It's up to you to decide, do you like this? Or do you not like? Do you think it's a bad idea? I will tell you, I didn't do a survey for this module since I have the final project still open, and we had some storms and stuff. But when I've surveyed the class, beginning when the bill was, 3 years ago in 2020, only about maybe 25% of the class thought this was a good idea. Then the next semester that went up to 33% or so, then to 40. Now, last time I did this, in the spring, we got very close. I think it was right over 50%, So what's really interesting is that more and more young people are thinking, maybe capitalism needs to be reformed, in a more substantive manner, in order to have more equity and more, more compensation to be more fair across the board. Now, probably the bill won't be enacted anytime soon, just because of, general partisan politics. But I think the ideas in the bill, whether you support the bill or think the bill is a bad idea, I think those ideas. Think of Donald Trump again in 2016. Winning the election because he represented employee interests. That kind of thing. I think the ideas in that bill will continue to be discussed and debated in the political arena, and some form of the Accountable Capitalism Act probably will eventually become part of the national conversation, in the next presidential election, or maybe by 2028, if we see the same trend where CEOs make a lot of money, but not everybody else is sharing in those profits. So throw that out there because I want to anticipate that discussion so that you can be informed citizens and then you can participate in that debate. You already know what people are talking about. I will just say, fingers crossed, we'll see what happens to the bill, and we'll see if, in fact, this could become a bipartisan, like we saw with the example of Donald Trump. All right. What I'm going to do here is, basically, we're ready to wrap up the semester now. We've talked about main theories of business ethics, the main forms of corporate governance, including a new experiment that Facebook is doing with its oversight board. And finally, we talked about the Accountable Capitalism Act, which would federalize corporation law and impose the stakeholder, or apply the stakeholder model to these big companies, and then have worker representation on the board of directors, as a sort of first step to getting the stakeholder model implemented. But I want to just close by giving you sort of the big picture. What was the most important thing? We had 5 classes, so we had 5 modules. I introduced to you sort of complexity by showing you that there's these 3 major areas of law, right? State and local law, right? But also federal national law, and then finally international law. And these can interact in different ways, right? Then we saw the common law, which is generally, at the state level, has a big pedigree going back to England. There are a lot of common law countries that have that heritage. And we saw, for example, 3 important areas that are relevant to all business firms, small and large: property rights, contracts, and torts or accidents, legal liability for when somebody gets injured. And we saw how the common law is a mix of bright line, clear-cut rules, and also sometimes general standards. Then in the 3rd class, we saw intellectual property rights, what I prefer to call the law of ideas. In that survey, we saw that every student in the class has created ideas. And what IP law allows you to do is basically you can own your ideas or the expression of your ideas. That's how most business firms, capture the value, of their new products and services, by owning the intellectual property rights that those products and services embody, whether it's a trademark and whether it's a copyright, a logo, whether it's a trade secret or a patent, the underlying invention or recipe or whatever. So IP law is super important if you want to grow a company or if you want to become a successful entrepreneur. You really have to take, and Facebook, I showed you the homepage when it was launched back in February of 2004. Even the Facebook homepage embodied a lot of valuable intellectual property. The source code, the copyright, the look of the website, and even the trademark, the Facebook logo, the Facebook trademark. All right. Then in our previous next to last class, I introduced, talked about civil and criminal cases, but there I focused on perhaps the most important idea that applies to both types of cases, and that is the idea of due process. In plain English, you have to treat, the legal system has to treat people fairly, even when they've been accused of doing terrible things. And the big idea there is that the burden of proof is always on the party, bringing the case, making the accusation. They have the burden of proof. And then we saw that burden of proof may vary. If it's a civil case, it's going to be the preponderance standard. But if it's a criminal case, right, it'll be proof beyond a reasonable doubt. And then finally, in this class, right, we saw the main theories of business ethics, main forms of corporate governance. And we saw how if the Accountable Capitalism Act ever becomes enacted, it would make dramatic changes to the existing law, at least for those big companies to which the law would apply. So as you can see, we've done a lot, and I think you now have a very good picture. What I want to close on then is with the final project. I hope at the very least the final project, again, just do the, just do each of the sections, make sure you address each of those bullet points, you'll get full credit. The main purpose of the final project though was to get each and every one of you to start thinking about, what is it that I want to do after college? Where do I want to work for? Who do I want to work for? What industry? So I want you to use this final project, do a little bit of research in that company or, in the industry to which that company belongs. And then, you can use that to try to, tailor your cover letter. You get an interview, you now know more about the company than maybe even the person interviewing you. You now have a huge advantage and you can use that, to accomplish your goals. And so please stay in touch. Those of you, and this is also on the recording, that are interested in law school, again, feel free to reach out to me as well, so I can help you with any questions you may have about the law school application process and about attending law school as well. I'll just say on a personal note, school experience, it was the most intellectually enriching experience I've had in my life, because you study a lot of cases, you study a lot of rules, but you study also how to apply the rules to facts. And so, which is what lawyers are really, trained to do. All right. Thank you for all your attention, for being here tonight for this last makeup class. I wish everyone the best of luck. God bless, and charge on. I'm going to go ahead and stop the